Hello, this is attorney Tara Hutchinson with Pittsburgh Family Law Services. Happy day after the Super Bowl. Although I am practicing out in Pittsburgh now, I actually grew up in Philadelphia, so the Eagles won the Super Bowl. It's a very great day here. Today I wanted to talk a little bit about what is considered marital property. This is a topic that's very confusing to a lot of people. It's not very clear what is supposed to be marital property, what isn't supposed to be marital property. So I just want to very quickly go over what that is. It's common that when you first sit down with a divorce lawyer, they're going to ask you, what type of property do you have? Do you and your spouse have any assets? Do you have any debts? And often when attorneys ask that question, the first things that people immediately think of are the assets that are jointly titled. So a house or a joint checking account, a joint savings account. The focus is on jointly titled assets. And that makes sense because in most contexts, if something is only your property, if your name is personally attached to it. So a lot of people leave out things like retirement accounts, because that wouldn't be jointly titled. That would just be in your name or just in your spouse's name. In Pennsylvania, the rules for determining marital property are a little different. So for marital property, we are looking at assets or debts that were acquired or that increased in value from the date of marriage until the date of separation. So what that means is that even if there are assets that are just in your name or just in your spouse's name, if you obtained it or if it increased in value from the time that you were married until the time that you separated, it is considered part of the marital estate. That doesn't automatically mean that every single asset gets divided up in half. It doesn't mean that. It means that when we are looking at what does the marital estate consist of, what is that value, we are adding all of that in and determining a total number, and then we decide who gets what and how it gets divided. There are, like so many areas of family law, there are obviously exceptions to this. So for example, if you have a prenuptial agreement that specifically excludes individually titled assets and debts, if you have that type of an agreement, that keeps it out of the marital estate. Same thing if you have acquired property through an inheritance and you did not commingle it, that keeps it out of the marital estate. But the default is going to be that if you acquired it or if it increased in value during the time that you were married, it goes into the equitable distribution pot, so that we get that large number, and then we determine how it gets divided. So that was just a very quick overview of the definition of marital property. I hope that was helpful. I hope that clarifies what lawyers are really asking for when we ask you what type of property do you have, what does the marital estate consist of. I hope that helps to clear things up a little bit. Again, please remember that although I am a lawyer, I am not your lawyer. So if you have specific questions about your particular case, please contact a local family law attorney of your choosing. Have a great rest of your day, everybody. Take care. Bye for now.